Hello, I'm Rodney Fong, President and CEO of the San Francisco Chamber of Commerce, and thank you for joining us today. This is Small Business Week here in San Francisco, and it's the Chamber of Commerce 17th Annual Small Business Week presented by Bank of America. And Bank of America has been a great partner of ours, and they are shining a light on incredible and resilient small businesses within our San Francisco community. A couple of highlights. The Chamber of Commerce WELL program, the San Francisco Department of Status on Women, and the Office of Small Business are coming together May 17th. Hold that in your calendars, May 17th, 11 a.m. for Women's Small Business Policy Update Roundtable. And every year, the Small Business Week Networking Mixer we have every year is on Friday, May 7th at 5:30. And be sure to keep an eye out for emails from the Chamber about a special offer from Spin. Those are those cool scooters around San Francisco, and you can get a free ride credits from Spin. So thank you, Spin, for that. Let's keep celebrating the Small Business Week here in San Francisco. And if you can check out more things that are happening this whole week, and they're going to be recorded on demand as well at sfsmallbusinessweek.com. You can register for those events. And there's a vast array of different workshops like this one we're about to start right now about how to start up a business, how to do marketing, how to be part of your community, and some very inspiring things on this week's calendar. I'm excited today. This is something we've all this whole year been asking ourselves questions about, and that is the legal world of COVID-19 and coming back out of it. What does that mean to us? And so today we have the pleasure of meeting with DLHA Law Group, who is going to talk about and uncover some of these questions: new legal challenges, new risks, comprehensive action-oriented assessments on a supplemental sick pay, what that means to small businesses, what that means to large businesses, what the American Rescue Plan actually is and how that impacts us, as well as reviewing the ever-changing landscape related to COVID-19, including employee certification for sick leave, employee COVID testing, whose responsibility, and the uses of vaccine policies. So I am very interested in finding this out. We've all been asking these questions. We'll also touch on today an update on the independent contractor law known as AB5. Joining us today is Angela De La Hoyce. Angela founded this law firm in the year 2000. And her legal career started with civil litigation and focused on business protection using experiential knowledge, and managing DLH's litigation strategy. So we are filled here with vast information from Angela and her team. And at this point, I'm going to ask Angela to take it away.
Well, thank you so much, Rodney. Thank you. And we're very happy to be here. Welcome to Legal Challenges and New Risks in 2021. As Rodney said, I'm Angela De La Hoyce. I'm founder of DLHA Law Group. I'll be introducing your presenters who are attorneys at the firm, as well as moderating at the end of the seminars, the Q&A session. This presentation, as Rodney said, will cover both state and federal laws, new changes to labor regulations, and COVID-19 vaccinations, and the overview of those vaccinations and requirements of employers. We will also cover lessons from corporate non-compliance. So I'll tell you really quickly a little bit about our firm. DLHA Law Group is a full-service law firm in San Francisco handling business law and employment-related matters. Our attorneys will be presenting, as Rodney said, on a host of topics, but to give you a broad overview, it's employment regulations, recent changes in the law, and corporate and business compliance. Thank you again to the San Francisco Chamber of Commerce for hosting all of these presentations. They're so incredibly helpful for our small businesses. To you, Rodney, for having us today, and to all of you attendees for taking the time out of your busy schedules to attend and learn a little bit about these areas. Without further delay, I'll introduce our speakers because we have a full presentation. But I do want to tell you that at the end of the presentations, I'll be moderating the Q&A session. So while the presenters are speaking, feel free to send a question through the question and answer box. Don't use the chat box because we won't be checking that, but the Q&A box at the bottom of your screen. If we don't get to your question, don't worry. You can either email us at info@dlhalaw.com, which should be showing on your screen at the bottom. and we'll be happy to respond to you. We do monitor those inquiries. So with that, let me introduce our first speaker, and that's Lauren Ocadiz. She's an associate attorney at the firm. She strongly supports the firm's litigation, compliance, intellectual property, and estate practice areas. Lauren will be speaking about California's new supplemental paid sick leave. Next will be Lindsay Meyer. Ms. Meyer is our senior employment counsel, and she leads our labor team practice, which handles state and federal employment laws. She'll be presenting on issues regarding employer-required health certification from employees, whether employers can require COVID-19 testing of employees and vaccinations. And last will be Kellen Stevens, our senior transactional attorney at the firm, who oversees all legal, corporate compliance, regulation, and contractual matters. He'll be covering the American Rescue Plan Act, or ARPA, subsidies, corporate compliance, and keeping your company's risk protections in place, which is also very important and something that's often overlooked until it can be too late. And as Rodney said, the AB5 recent changes and updates. We won't be going over all of AB5, but just the recent changes and updates. So with that, let me introduce Lauren Ocadiz. Lauren?
Thank you for the introduction, Angela. Well, thank you again, everyone, for being with us today. As Angela mentioned, I'm going to be speaking to you about California's new supplemental paid sick leave law, also known as SB 95. So many employers have come to us asking us, what is this new law? Does it apply to my business? And what do I have to do to be compliant with the law? So we're going to be answering a few of those questions today. So let's begin. So what is SB 95? Well, on March 19th, 2021, Governor Newsom signed into law SB 95, which is now called California's COVID-19 Supplemental Paid Sick Leave Law. That's a mouthful. So I'm going to abbreviate the law as Supplemental Paid Sick Leave Law. So this new law is in effect now and will remain in effect through September 30th of this year. So what this new law requires of employers is that employers with more than 25 employees must provide up to 80 hours of COVID-related sick pay leave. So this is mandatory for California employers with more than 25 employees. What this also means is that those employers with less than 25 employees are exempt from this law. So I do want to speak about a unique provision of this law, and that is the retroactivity. So the retroactivity of the law applies up from January 1st to present. So what does this mean? Well, if an employee has taken leave for one of the qualifying reasons, which I will explain to you shortly, under this new law, and the employer did not pay the employee for that time off, the employer must pay the employee if the employee makes a written or verbal request to the employer for this particular paid time off. Once the verbal or written request is made to the employer, then the employer's obligation kicks in and the employer must pay the employee for that particular paid time off. And it must show in the next pay period after the request was made. An important note, though, for employers is that this request will need to be made on or after March 29th. March 29th is the deadline in which the law actually went into effect for employers. So if the employee makes this request before March 29th, it is invalid and it does not count. Furthermore, many employers have asked us, do I need to go back and audit my records? No, the Labor Commissioner has made it clear that employers do not need to go back and audit all the leaves that were taken since January 1st. Again, the obligation kicks in once the employee makes the written or verbal request to the employer for that particular paid time off, and it was on or after March 29th of this year. So another unique provision is that this supplemental paid sick leave is in addition to regular paid sick leave. So this means that those 80 hours of supplemental paid sick leave is in addition to the paid sick leave that an employee is already entitled to under either state or local law. Another important aspect of the law is this prohibition on forcing employees to use other leaves first. An employer may not force a covered employee to use any form of either paid or unpaid leave or time off, including company provided sick leave, vacation, paid time off, before using this supplemental paid sick leave. So now I'm going to be talking to you about the qualifying reasons, which have actually expanded. So the covered employee, another important aspect is that now this law covers not only those employees that, were unable to go to work, but now remote employees. So the covered employee must be unable to work or telework due to any one of these following reasons. The first is caring for yourself. The employee is subject to a quarantine or isolation period related to COVID-19, or the covered employee has been advised by a healthcare provider to quarantine due to COVID-19, or the covered employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. Another one of the qualifying reasons is caring for a family member. The covered employee is caring for a family member who's either subject to a quarantine or isolation period related to COVID-19 or has been advised by a healthcare provider to quarantine due to COVID-19. Another qualifying reason is if the employee is caring for a child whose school or place of care is closed or unavailable due to COVID-19 on the premises. And the final qualifying reasons are vaccine related. So if the employee is attending a vaccine appointment or cannot work or telework due to vaccine related symptoms. So those are the qualifying reasons. There's 7 of them. So they have expanded. Best is to just review the law if you're unsure and reach out to us if you have any questions. Another question we've received from employers is, can they credit or offset hours that they've already given since January 1st? So excluding regular paid sick leave, this law does authorize an employer to credit or offset the hours towards the supplemental paid sick leave requirement. However, it would need to be under certain circumstances. And so those certain circumstances are if the retroactive payment is for leave taken by the employee between January 1st and March 28th. The second is if the leave is taken by the employee for one of the qualifying reasons under this supplemental paid sick leave law. So it needs to be one of those 7 in order to qualify. And finally, the retroactive payment by the employer pays the covered employee the amount required under this law. So it can be equal to or greater than, but it needs to be calculated in the same way as the supplemental paid sick leave law. So under those 3 circumstances, an employer could credit paid leave for those for that time taken off since January 1st of this year. So this actually takes me to the next segment, which is the calculation and caps of this. So in terms of the amount of paid sick leave that's required to be paid under the law does provide that employer must pay up to 80 hours of paid sick leave if the employees are considered full-time employees, or if the employees work a schedule of an average of at least 40 hours per 2 weeks before the date in which they took the paid sick leave. If the employee works a part-time schedule, so a regular part-time schedule, the employee is entitled to supplemental paid sick leave in the amount of hours worked over a 2-week period, And if the employee works a part-time or variable schedule, the law states that the pay is 14 times the average number of hours worked during a 6-month period of time. So the law also states how employers must calculate each hour of pay for exempt and non-exempt employees. The rate for which non-exempt employees is calculated is based on the highest of these 4 following ways of calculating it. The first is the same calculation as used in determining the regular rate of pay for that particular employee, or dividing the employee's total wages, not including overtime, by the total hours worked in a full period in the prior 90 days of employment. Third, state minimum wage or local minimum wage. For exempt employees, paid sick leave is calculated in the same manner for other forms of paid leave. Another important thing to note is that there are caps on how much an employer needs to pay for the paid sick leave. And so employers are not required to pay more than $511 per day and $5,110 in the aggregate to one employee. So now I just wanted to go over an example of how offsetting works. So if, for example, an employer extends to an employee 3 hours of leave taken under the Families First Coronavirus Act, so the FFCRA, on or after January 1st. So if the employer extends these 3 hours, and let's say the employee requests the time off on February 2nd, okay, and this is a full-time employee, And let's say that the qualifying reason under the FFCRA was that the employee was experiencing COVID-19 symptoms and is seeking a medical diagnosis. Now, that is a qualifying reason under this new COVID-19 supplemental paid sick leave law. So going back to the offsetting, if the employee requests for this time off between January 1st and March 28th, so the employee actually requested it on February 2nd, that's okay. And then the qualifying reason is one of the same qualifying reasons under this new supplemental paid sick leave law, which was experiencing COVID-19 symptoms and is seeking a medical diagnosis. And finally, if the employer makes the same calculation and pays the employee as required under this new law, either greater to or equal to, in that case, an employer could credit the paid leave provided to that employee. So instead of that full-time employee receiving 80 hours, they would be receiving 77 hours under this supplemental paid sick leave law. So again, if you have any questions, please feel free to reach out to us. We'd be happy to talk to you. Every circumstance and scenario is different. The facts are different, which would require a unique analysis in each scenario. And so with that, I just want to talk to you really quickly about these new employer obligations with this COVID-19 supplemental paid sick leave law. The first is that covered employers must take immediate steps to adjust their wage statements, so pay stubs. Specifically, the pay stubs must list any supplemental paid sick leave as a separate line item and list all available paid sick leave hours separate from other paid leave. So if you haven't done this already, please reach out to if you use ADP or if you do it yourself, please go to them and ask them, I'm a covered employer, this information needs to be conveyed on my pay stub. Are we doing this? Because that's really important that in order for you to be complying with the law, that is a new employer obligation. And the last is, in addition to the wage statements, covered employers must post a supplemental paid sick leave notice in a conspicuous place in the workplace. However, if most employees are working remotely, which is kind of the general consensus right now, employers may email the notice to those workers not frequenting a workplace. And so this particular notice is available online on the Labor Commissioner website. But if you can't find it or you need assistance, please reach out to us and we'd be happy to direct you in the right direction. And that concludes my segment. Thank you, everyone. And I will turn to Ms. Lindsay Meyer. Thank you.
Thank you, Lauren. Good afternoon, everyone. I am Lindsay Meyer. I am happy to be presenting to you all this afternoon. I'm going to be covering some of the top questions, actually top 3 questions that our firm has been receiving from our employer clients that are related to COVID and the continual change in the law regarding this subject matter. So first of all, I will discuss healthcare provider certification regarding employee sick leave. So as Lauren just explained in detail, under the recently retroactive SB 95, employees are now entitled to supplemental sick leave through the 30th of September of this year. Now, employers have been asking us, what type of documentation can I ask my employee for before I permit them to use this supplemental sick leave? Well, generally, when an employee asks for time off for sick leave, or if they need to take a medical leave of absence, it's fairly customary that employers will ask for a doctor's note. But when dealing with this supplemental sick leave in particular, it's very important to note that while employers can request a doctor's note, it cannot be required. And this is very important because this would be a violation of the law on behalf of the employer if they withhold or deny an employee's time off and pay under the supplemental sick leave if the employee fails to provide a doctor's note. So if upon the employee asking the employer for time off, either orally or in writing, the employer must immediately grant the employee's time off and provide the available supplemental sick leave available for that individual employee. Now, again, certainly an employer can request a doctor's note. Most employees are willing and able to do so. But if for some reason the employee isn't able to or doesn't provide a doctor's note, you cannot delay, postpone, withhold, or deny providing the employee that time off if they're qualifying to use the supplemental sick leave. And the same actually goes if an employee has available paid sick leave under the law, which all of us as California employers are aware that all employees at a minimum must receive 3 days of sick leave in general, and that does not relate to the supplemental sick leave. So again, employees must be permitted to use that supplemental sick leave. A doctor's note can be requested, it cannot be required, and the sick leave must be provided immediately, as well as the pay. And I know there's probably a lot of other questions you have that are related to that, so please feel free to ask me and I will respond at the conclusion of our presentation, time permitting. Now, I will move on to discuss a very popular question we've received about testing of employees. Many of our clients have contacted us and want to know, are we now able to require our employees to submit to COVID testing? Now, here we'll discuss federal and California law, and the reason I bring that up is because many employers get confused about, do I follow the EEOC? Do I follow the California Department of Fair Employment and Housing? Well, in this particular instance, under federal law, in response to the question, can employers require COVID-19 testing of their employees before their employees enter the workplace? The answer is simply yes. The EEOC updated its advice regarding COVID-19 testing, and they have advised that testing is permissible. And the EEOC bases its reasoning on the fact that such testing is job-related and is consistent with a business necessity, and that an employee with COVID-19 would pose a direct threat in the workplace. So for these reasons, the EEOC federal law concluded employers may require such testing before allowing employees to enter the workplace. Now, in California, under California law, it's in line at this point with federal law. The California Department of Fair Employment and Housing has also advised that employers may mandate a medical examination when it is job-related and consistent with a business necessity. And when applying this standard in light of the guidance from federal law under the EEOC, as well as the CDC, employers may require employees also to submit to viral testing before permitting employees to enter the workplace. And that's important to when I said viral testing, because antibody testing is different, and I'll get into that a little bit in more detail in a moment here. Now, again, under the Department of Fair Employment and Housing, they're advising that employees can be required to submit to the viral testing before entering the workplace by the employer, because an employee with COVID-19 would be unable to perform that employee's essential duties in a manner that would not endanger the health or safety of others in the workplace, even with a reasonable accommodation. So again, under federal and California law, employers may require employees to submit to viral COVID-19 testing before entering the workplace. Now, some employers have opted to conduct less invasive methods of health screening. That's certainly appropriate. One such method would be to require employees before reporting to work each day to take their own temperature and to complete a symptom questionnaire. Only employees that do not have a fever or any possible COVID-19 symptoms would be permitted to report to work. These are simple and cost-effective ways to help minimize the spread of COVID-19 in the workplace. So that's an option. Another option is, instead of requiring employees to submit to the viral testing, employers can offer voluntary COVID-19 testing to employees, which the employees would consent to in writing. Now, it is very important for employers to pay attention to local orders, because sometimes the local orders may provide even further direction regarding permissibility of the COVID-19 testing. For example, in Los Angeles County, the Department of Public Health regarding the music, TV, and film production industry has provided further advice regarding and guidance regarding COVID-19 testing. And it actually says for that particular industry in that county, there must be regular periodic testing of the cast and crew on a given production to mitigate the risk of the spread of COVID-19. And this is especially pertinent because cast and crew are often involved in high risk scenes where they're acting, they're not wearing masks, and they're in close contact. So in Los Angeles County, for that particular industry, not only is COVID-19 testing permissible, but it's also required. So to ensure legal compliance, employers absolutely should pay close attention to any updates to the local orders in areas that their employees are working at. I know many businesses have multiple areas where their employees are regularly perform their work duties. So again, just be up to date on your local orders just to make sure there's nothing providing additional further guidance or requirements regarding such testing. Now, implementing testing. If you choose to offer the COVID-19 testing, you want to make sure that you are offering the viral. So today, under federal and California law, employers cannot lawfully require employees to take antibody tests. The EEOC has explained that the reason for this is the antibody testing does not meet the ADA's job-related and consistent with business necessity legal standard for a medical examination or inquiry for current employees. So while the EEOC does not expressly prohibit employers from offering antibody testing on a voluntary basis, doing so may be more of a risk to the employer than a benefit. So we recommend at this point, because there's no further guidance on that, and it's clear that under the law, employers cannot legally require antibody testing at this time, to just offer or require the viral COVID-19 testing if that's the direction you want to go in with your business. Let's see here. So further, besides making sure when you're implementing this test that you're picking the right test, which would be the viral COVID-19 test, you want to make sure that it's a reliable and effective test as well. In doing so, you want to make sure you select a reputable testing company to conduct the COVID-19 testing, depending on how you want to structure that within your business. It certainly can be challenging to ensure quick turnaround times, but it's really important to make sure you find a company who can do that, because the longer the turnaround time, the less useful the test will be. Because every day between the employee's test and their return to work date is another day they may have been exposed to the virus. Accordingly, to the extent possible, employers should contract with reliable testing companies and ensure that they conduct the test within 24 to 48 hours before the employee is expected to return to work. Also, employers, if they're implementing some sort of testing policy, you want to make sure that you create a written testing policy that would support the employer in a defense against any claims of potential discrimination by employees. Without a written policy, employees may claim they were singled out for testing based on illegal considerations. So it's very critical, if you are going to implement some type of required or voluntary testing program in your workplace, that you have a written policy in place that ensures your legal compliance. Additionally, to comply with HIPAA and California's Confidentiality of Medical Information Act, which employers must comply with, the CMIA, employers must obtain signed employee authorization forms in which the employee is not only consenting to the test, but also authorizing the employer to consider the test results when determining the employee's eligibility to work, meaning whether or not it's safe for the employee to integrate back into the workplace. So depending on the language used, these forms may permit an employer to actually receive directly the employee's test results from the laboratory that conducted the tests. Many employers who are deciding to use these type of testing policies within the workplace want to be able to receive the test results instead of relying on the employees to, truthfully report back what the results are. And again, employers are permitted to do this, but you want to make sure you have a proper legally compliant consent and authorization form. So please consult with your legal counsel if you want to implement that type of testing program. It's further important to remember that all test results must be kept confidential, and they are considered confidential medical information under both state and federal law, which means they must be kept in a separate medical file, separate from the employee's personnel file, that is only viewed by members of management on a true need-to-know basis. Any information about the employee's COVID test result may not be shared with any other employees. Now, if an employee does have a positive test result, again, the employer cannot reveal that individual employee's identity to others in the workplace. However, employers do have a duty to notify other employees that that individual employee may have exposed COVID-19 to. So again, you can notify those employees they may have potentially been exposed by a coworker to COVID-19. You just cannot reveal the identity of the employee that tested positive for COVID-19. And lastly, besides deciding whether or not you'd like to implement a COVID-19 testing program within your workplace, employers should still continue to use other preventative measures. So even if you are conducting regular testing of employees, employers should keep in mind COVID-19 testing is not 100% reliable. It's certainly possible for an employee who is infected with the virus to test negative, and for an employee who does not have the virus to test positive. So where possible, employers should absolutely continue to use other health screening methods, which would include, taking temperature and the symptom questionnaire I mentioned earlier, in conjunction with the COVID-19 testing. And also it's important that even if employees are being tested, to maintain to the extent possible the physical distancing, proper hygiene, wearing of the face masks and other personal protective equipment, and that employers continue to follow the CDC's cleaning and sanitation protocols. Those are the best methods to ensure, limiting the exposure of other employees and preventing an outbreak of COVID-19 in the workplace. And with that, I will turn to my last really high topic of interest from employers, whether or not employers can mandate COVID-19 vaccinations for their employees. Again, federal and California law are essentially in line on this issue as well. Under federal law, per the EEOC, employers may encourage or possibly require COVID-19 vaccinations, but the policy must comply with the ADA and Title VII of the Civil Rights Act, as well as other workplace laws. So, for example, an employee with a religious objection or a disability may need to be excused from the mandate or otherwise accommodated. And again, this is similar, essentially the same as California law. Under the California's Department of Fair Employment and Housing, it also advises that employers may require employees to receive an FDA-approved vaccination against COVID-19 infection as long as the employer does not discriminate against or harass employees or applicants on the basis of a protected characteristic, including disability and medical condition, not limited to, but including, that the employer provides a reasonable accommodation related to disability or a sincerely held religious belief or practices, and that the employer does not retaliate against anyone for engaging in protected activity, which would be, for example, requesting a reasonable accommodation if they believe that they cannot or should not be receiving the COVID vaccination. Now, how should employers respond to employees that cannot or will not get the vaccination? Most certainly the scenario will arise, especially the larger workforce you have, the more likely you'll have individuals who advise that they cannot be vaccinated for either religious or medical reasons. Now, if an employee refuses to get vaccinated due to sincerely held religious beliefs, employers must provide reasonable accommodations unless it would pose an undue hardship to the employer. And the EEOC has advised that because the definition of religion is broad and protects beliefs, practices, and observances that the employer may not be familiar with, the employer ordinarily should assume that an employee's request for accommodation is based on a sincerely held religious belief. So in other words, the employer should generally not question employees about their religion. If employers, if they have an objective basis for doing so, it may be okay, but in general, employers should take the employee's word for it that it is in conflict with their religious beliefs and provide an accommodation if at all possible. Now, if an employee refuses to be vaccinated for a disability-related reason or a medical condition, again, employers must also take steps to provide reasonable accommodations unless and until the accommodations become unduly burdensome to the employer. And that is a very factually specific analysis that must be done. So if an employer believes for any reason that they cannot accommodate an employee because of a religious or medical reason, it's imperative that the employer consult with legal counsel before making that decision to, exclude that employee from the workplace. Now, as far as reasonable accommodations, some reasonable accommodations for employees would include allowing them to work remotely if that's possible for their position, or adjusting the employee's duties in a way that would prevent them from coming in close contact with others. So those are a few reasonable accommodations that could be used. Now, an employer may exclude an employee from the workplace if having the unvaccinated person on the premises would pose a direct threat to the health and safety of other workers. But again, even if such a threat does exist, employers should always analyze the facts of each employee's case closely and make individualized determinations with the help of legal counsel. Now, another question we've received from employers along this line is, what if an employee has a concern that the vaccine is not safe? Is that enough, or does it have to be based on a religious or medical reason that they believe that they cannot be vaccinated? If an employee just feels that they're concerned that it's not safe, that's probably not enough. Employers are only required to accommodate employees regarding not getting the vaccine based on a disability or a sincerely held religious belief. And as far as whether employers can require employees to submit proof that they've received the COVID-19 vaccination, yes. According to the California Department of Fair Housing, that is permitted. Proof of vaccination is not a disability-related inquiry, religious creed-related inquiry, or a medical examination. So employers absolutely can ask for written proof that employee has received a COVID vaccination. Because COVID-19 vaccination documentation could include other medical information, employers should instruct their employees or applicants to omit any medical information from the documentation other than the proof that the employee received the vaccination. So that's important to remind employees. You're only asking for proof of the vaccination, and any other medical information of the employee should be omitted. Also, employees, if they have been vaccinated, it's important to just still treat them the same as employees who have not been vaccinated, still implement all of the safety precautions, have all employees, whether or not vaccinated, continue to wear the face covering, social distance, follow all safety protocols. And I know that was a lot of information. So again, you may have some more specific question along those lines. Please feel free to follow up. And with that, I will go ahead and turn over to Kellen Stevens. Thank you.
Okay. Thank you, Lindsay. That is a lot of pertinent information that we've definitely reviewed with a lot of our clients. And so I'm glad that we're able to share it with the SF Chamber attendees. So what I'm going to be talking about is essentially two parts. One is a segue. I'm going to talk about the American Rescue Plan Act and kind of the portions that relate to employers, and some of this relates to COVID. And then I'm going to move on to corporate compliance and AB5, the independent contractor law, which also are, kind of AB5 is constantly changing and consistently an issue with our clients. And B, corporate compliance is a big part of just insulating yourselves as a company. And so we just want to make sure that we review that because it is so important for owners of businesses to maintain their insulation from liability. So I'll start with the American Rescue Plan Act. This was, effective March 11th. It included a handful of things like child tax credits, homeowners assistance, rental assistance, unemployment insurance, but we're going to be focusing on some of the business aspects. So the first is voluntary paid sick leave. Under the Families First Coronavirus Response Act, employers with 500 or fewer employees had a mandatory paid leave that they had to offer. That expired December 31st. It was extended through March 31st as a voluntary participation scheme. And now that voluntary participation scheme has been extended again, starting April 1st through September 30th, 2021. Now, if an employer elects to participate, they must provide 80 hours of sick leave and 12 weeks of extended family medical leave. There's also a lower threshold for part-time employees. The participation is treated as a hard reset. So even if an employee exhausted their entitlement under the Families First Act, they have another 80 hours. However, there are no rollovers. So if they had time before, it doesn't roll over now. It's hard reset, 80 hours. To pay for this or incentivize employers to provide this, the government is offering tax credits against the employer share Medicare taxes. And there's a refund that will be available if the amounts claims exceed the taxes paid. The total amounts offered are $511 per day for employees for sick leave, and then 12 weeks at 2/3 rate of pay up to $200 per day and $12,000 in the aggregate for family medical leave. And so you just have to keep track of that as it's offered. The reasons that people are using this or that it's offered, that they can use this type of sick leave or family leave are all related to COVID. There was the sick leave, quarantine, isolation, diagnosis, caregiving for family members afflicted by COVID, recuperating. They've also added categories related to vaccinations, so time off to get vaccines, to recuperate from them, and to care for people that are doing the same. So those are just some of the broad categories. If you are electing to provide this to your employees, know that the time that they take for this has to fall within these coronavirus related categories. The other important thing to note for employees is that there are non-discrimination requirements. What that means is that if you provide to one person, you have to provide to all the individuals and all the employees. That is certainly a consideration with employers that have as little as 20, as many as 200 or 300 employees. You can't just provide it to highly compensated individuals like executives. You have to also provide it to all the employees, which means that you have to account for that and do kind of some financial analysis and planning to see if it makes sense. Which, when you do that, it makes sense to look at, what are the rates in the area. I know San Francisco just moved down to like the yellow tier. And so you kind of look at that, how important is it for employees to have this leave, how many would take it? So you can do some analysis there. Now, the second part of the ARPA is the Cobra Continuation. And so that's on the next slide. And what essentially this is it created a mandatory continuation of Cobra and a mandatory required premium subsidy by the employer from April through September. 100% of the subsidy is offset by tax credits. The people that are eligible for Cobra are those who are involuntarily terminated or had a reduction in hours. Those people, we kind of look at them in like two different classes. So it's people that are, and I'm just going to say if they're terminated or reduced in hours, I'm just going to refer to that as terminated. So terminated employees after April 1st who become eligible for Cobra, or if they were terminated before April 1st, up to 18 months before, and they were offered but declined, or they're no longer eligible, they have a special opportunity, no longer eligible because maybe they didn't make payments. They have a special opportunity to elect Cobra benefits if they notify you 60 days after they receive notice from you. I'm going to go over the notice section. If you have already, if they have already paid, elected Cobra and paid for Cobra, in April or May, you actually have to refund that amount to them. So that's important to know, and you want to be tracking this. And the employees who receive this premium subsidy are also required to let you know when they become eligible for other insurance. The exact way they do that is still the nuances of that are being defined by the Department of Labor, but it also appears that they would be penalized if they intentionally kind of fail to provide notice. So let's just talk about the notices. If we look at the first category of people, those who are current Cobra beneficiaries or who lost plan coverage prior to April 1, you have to notify them that they can receive subsidized Cobra coverage effective April 1 by May 31st. So you have the next month to do this. And the next set of people is those that will be terminated after April 1st. With those people, you have to provide a notice that they have the opportunity to elect, that they have an opportunity to elect this, that it'll be subsidized from April 1 through September 30th, 2021. The other notice that you have to provide is if any of these people have elected for the coverage, you have to notify them 15 to 45 days before the premium subsidy expires so that they know about that. Generally, now the Department of Labor is going to provide model forms, and I think they might already be up there now. But the notice has to include, a description of the right to receive the premium, the conditions they have to meet, a form to request it, those types of things. It's really just trying to get this out to employees who are eligible because it's a mandatory program. So that's my end of kind of the COVID-related parts of the American Rescue Plan Act. Again, it's all meant to protect employees and provide healthcare coverage, allow them time to take time off to recuperate or recover, anything related to COVID. So that's the COVID-related sections. And now I just want to move into corporate compliance, which doesn't sound fun, but it's a big part of my job. So in corporate law, we always talk about piercing the veil. And this is something called like the alter ego doctrine. It's something that's applied by the court, not the juries, because it's an equitable doctrine. It essentially allows the owners of a business to become liable for the claims against the company. The two important elements are whether there's a unity of interest between the ownership or individuals, that such that like their personalities, like the entity and them, no longer exist, and a failure to hold them accountable would promote like an inequitable result. Now, a lot of people ask, does this really happen? And fortunately, we had this comprehensive case study looked at cases in California from 1996 to 2005, and it found that actually courts pierced the veil in 33% of cases. Which means that the owners became liable for the debts or obligations or personal injury liability on a property, which is quite significant. If you think that there's a 33% chance of liability in a given scenario, then you really have to control and account for that risk and try to mitigate it as much as possible. And so what can you do to mitigate that? We'll go on to the next slide here. I can kind of talk about that. The first thing is, overall corporate formalities are a routine part of running an entity, but they are very important. The first thing that California especially really focuses on is inadequate capitalization. Do you have enough money to fund the ongoing operations, the debts, the liabilities, of your business? If that's not there, there's going to be a strong presumption that there was a unity of interest because you didn't really create this entity that was properly capitalized. The other things to really focus on are co-mingling. A lot of people are aware of this, but we see it happen so much. So does the CPAs that we work with, where you have a company and the owners might write checks to themselves or kind of loan money between them without an agreement or without, like the lowest federal interest rate, which means that it's not an arm's length transaction. In that case, you're kind of merging those two interests and, or using funds between them, or even just like sharing office space. If the company owns office space and you have a separate company that you're running and you're just using some of that space. I mean, if there's no agreement to the parties and suddenly you and the two companies seem to be working together, and there's not that separation between them. And so you really want to avoid commingling. And if you have to use share resources, you kind of have like, simple agreements between the companies saying, oh, this is what we're doing, this is how we're compensating, and you can usually find like the minimum amount of compensation necessary. The other really important thing for that we see with our clients that we help with is just maintaining corporate records. This is especially true for companies, small companies that need to keep their annual minutes. You have to formalize your minutes, sign them, say what you've done in those minutes over the past year. You have to conduct your meetings, and you have to make sure that the decisions that you make are reflected in those minutes or voted on at those meetings, and that all of that is consistent with your organizing documents. So if you're an LLC, it's going to be an operating agreement. If you're a corporation, it's going to be your bylaws. But I mean, that's a really important thing. We also see this where people make decisions that are supposed to be, say, go to a vote of the members, but then one person just does it without voting. And that's violating the rules of that business. And then that's something that can then lead to, among other factors, piercing the veil. So it's just kind of following those routine formalities that you don't always think about. But in the long term, if you think that if I do this and there's some sort of liability that happens, there's a 33% chance that the veil is pierced just overall. And then if you're not doing those things, that probability increases. So the last thing that I would like to talk about is AB5. I'm sure you're all pretty aware of this. It's still the law of, I say this land in California, although there was recent changes in the Biden administration signaling that there might be some federal law related to independent contractors and employees. But basically this is a presumption that in California that everyone's an employee unless they meet this three-factor test. So they have to be free from control and direction. They have to perform work that's outside the course of that business's work, and they have to do it like separately, like they customarily engage in that work. For what I've seen, most employers fail prong 2. They usually give enough agency to meet prong 1 to an independent contractor, but they're engaging them for things that they might also already do. And in that case, they fail prong 2 because it's not outside the course of that entity's business. And then that means that if you fail one prong, then you fail the test. And if you fail the test, that person is not an independent contractor, but they are an employee. One of the ways that you can survive in the event of a failure is if you meet an exemption. Those exemptions were increased. There's about 109 total categories of exemptions now. So those are categories, not specific ones. These were increased under AB 2257. A large part of this was motivated by the entertainment and music industry. We saw this happen. A lot of our clients were involved in this. And now like writers, photographers, fine artists, content contributors, they are now under these exempt categories because their business models are really that where they are just kind of coming in and out. And it was part of the business of the hiring entity, but they needed an exemption and they got one. So do we expect there to be more exemptions? Probably, as more industries are affected by the law and the economic consequences of what's happening are assessed and validated, then the legislature or the independent businesses are going to make changes that may benefit employers or it may not. So it is changing. And the most important thing to do is if you have an independent contractor, you want to assess whether you are classifying them correctly, whether they're an employee or an independent contractor, whether they meet the tests, the three-pronged test, or whether there's an exemption. And to do that, it does help, I say speak with your attorney, because applying these and using the case law and being apprised of all the changes it's important to have someone that's conversant in those issues and has seen them come up multiple times. So that's what I would advocate. And that concludes my portions of the presentation. I want to thank everyone for participating. And I think that we're going to move on to the Q&A now, right, Angela?
Exactly. Thank you, Kellen. And thank you to all of our presenters. We really appreciate it. We have several questions that have come in, so we're going to go ahead and take those. I think we can take them in order that they were submitted for now. I'm going to be asking each of the presenters directly to answer the questions. And if we don't answer your question completely, or you would like us to follow up with other information, please do not hesitate to email us at info@dlhalaw.com. So the first question is from Ryan, and that's actually, let me caveat all this because I do have to say, or my team will get upset, that because we are sitting down and meeting with you individually and asking you questions and getting all of the facts and the history, we aren't able to provide legal advice. So don't rely on this and act on it. Like, don't do this at home because there may be a factual scenario that we're missing or information that we're missing that would change the course of our advice. And, the law is not just based on the legal regulations, codifications, and case law. It's also based on the factual scenarios that apply to that law. And one small fact can change our entire juxtaposition on a case. So please know that this is informational only, but we'll try to help guide you through some of these things. So the first one is, what if an employee lives with someone that is diagnosed with COVID, but it is not their family member? So I'm going to ask Lauren to answer that question, if you could, Lauren.
Yes, so if this is in relation to the California Supplemental Paid Sick Leave law, the short answer is no. The reason being that is not one of the qualifying reasons under the supplemental leave law. An employee is eligible for the supplemental paid sick leave if the employee is caring for a family member whom a medical professional has recommended that they stay home because of COVID-19, or the family member is subject to a quarantine issue or isolation period, as defined by, the guidelines of the California Department of Public Health, or the local kind of health officer. And so under this particular law as well, a family member is specifically defined. And so that doesn't include a roommate, but it does include, a sibling, a grandchild, a grandparent, a domestic partner, a spouse, and a child that includes biological, adopted, or foster. So it's very specific. However, like all scenarios, facts do change. So in the event, if that employee who's been exposed to COVID-19 starts experiencing symptoms related to COVID-19 and now needs to seek a medical professional medical diagnosis, they may be eligible for the supplemental paid sick leave.
Thank you very much. The next question is from anonymous attendee. If an employee is from Linda, that I guess the one moved over. If a business hosts an event and attendees contract COVID-19 while safety procedures were in place, what are the legal liabilities for the business? I will take that one. When we're asked what are the legal liabilities, that can be a pretty broad question. There could be city ordinances that are breached. There could be general torts. There could be breach of contract. So there could be many different potential legal liabilities. So it's a little bit hard to answer that in a vacuum. What I can say is that our firm's been preparing a lot of waivers for smaller businesses or mid-sized businesses to have attendees sign. That's harder to do on a large scale project basis or a large scale concert or other kind of venue because they're considered, or they can be considered, contracts of adhesion for attendees, because the attendees aren't likely to read the back of a ticket stub or submission document carefully, and usually the print is very small. So those can be challenged in court and usually pretty successfully. Where there's an issue though is the area of proximate cause. Did the attendance at the event actually proximately cause whatever the damages are? So that's usually where the plaintiff is tripped up. But so it's a little bit difficult to answer that in a vacuum. I'd be happy to talk to Linda directly or answer some of your questions directly if you want to email us your specific factual scenario. But what I can say, a bigger issue is that we are seeing insurers redefine their insurance policies, scale them back, issue new policies with a lot of exclusions. A lot of times infectious disease coverage is now being excluded. So I would recommend as a business owner that you have your general liability and other specific coverage policies reviewed by counsel. That's where you may blindly be relying on insurance counsel to come in and defend you, and you may be very surprised to see that an exclusion applies. So I would say on a bigger level, more broad exposure, going forward, you may decide not to host an event if you think you're not covered with your general liability coverage because there's an exclusion. So let's see, the next one is anonymous, and that's 1239 question. If an employee is taking a family member to get vaccinated, can they use supplemental paid sick leave for that? And I believe that that's Lindsay, are you answering that question?
Sure.
Okay.
Yes, absolutely. So if an employee is going to get personally vaccinated, then yes, they can use that supplemental paid sick leave. However, if an employee is taking a family member to get vaccinated, no, they do not qualify to use the supplemental paid sick leave. If they are caring for a family member, as Lauren just advised us, that qualifies for the for them, then they can use that supplemental paid sick leave to care for the family member. But just simply taking a family member to get vaccinated does not qualify that particular employee to use that sick leave.
Okay, great. Thank you. Lindsay, I'm going to see if you can take the next one because I think you were speaking to this subject when this question came up from Adrina, and that's 1242 question. I couldn't get if employers or schools can ask for vaccination proof or not legally. I think she was just asking for a clarification.
Sure. So under federal and state law, employers can require their employees, they can mandate vaccinations. However, they have to be able, and they must make accommodations for those individuals who may not be able to get the vaccination for medical reasons, or who will not because of a sincerely held religious belief. So there are, qualifications to being able to mandate the vaccine, but employers can ask for documentation confirming that the employee was vaccinated. That's permitted. And I believe actually as far as schools, it was recently in the news that Rutgers University was the first public university that is going to be mandating the COVID-19 vaccination. And there's strong legal precedent that schools have been able to require immunization. So, it's looking that way that schools will be doing the same thing. But as far as employers in California, yes, they generally can mandate that employees are vaccinated for COVID-19 with the exceptions that I already went over in the presentation, and they can ask for documentation as well. But just documentation saying whether or not the employee has been vaccinated, but make sure that employee omits any other medical information, because the employers aren't entitled to just the entire medical record of the employee.
Thank you. Next question at 1244 from anonymous attendee. How do I know when to apply the newer federal law or the California supplemental sick leave law? Kellen, why don't you take that one?
Yeah, sure. That's a good question. So the California law and the federal law were actually written kind of similarly and at the same time. And you can see that the California law tracks a lot of the language and timing as the federal law. And so the idea was that you could kind of rely on both. So I don't want to get too technical, but overall, it's definitely possible that the sick leave that's required to be provided under SB 95 is also the same leave that you can voluntarily provide under the ARPA. And so if you voluntarily elect into providing the ARPA 80-hour sick leave and you have the SB 95 sick leave that's required, then if that's the case, when someone goes out sick, you can claim the ARPA tax credit for that sick leave, for that qualifying paid sick leave. However, and this is just, I wish it wasn't like this complicated, but there are, even though the laws, all the dates and a lot of the definitions line up the same way, there are some coverage gaps between the two things. And so you just want to look at, like, I think that one of the coverage gaps was the way that the California law defines like government orders, like stay-at-home things, was like actually broader than the federal one. And so in that case, if someone wasn't taking sick leave because of this larger, like, kind of state-based thing, then you couldn't claim the tax credits for that because it wasn't the type of order that the federal law described. And that's just where they're disjointed. They were inconsistent, which is too bad. Most of the other leave, like if it's recuperating, if they have COVID, if it's like vaccine related, those are usually going to be coextensive. So, my advice would be, if you elect to provide this voluntary leave under the federal law, so that you can apprise yourself of these, like, or take these tax credits, then what I would do is, if you're doing that, if someone does take sick leave and they're clearly taking it, it's permissible, it's related to COVID-19, then you kind of look at that and say, okay, what was the reason for that leave? And then, the best thing to do is, like, well, if you're claiming tax credits, you can either talk to your CPA or you can talk to your attorney and say, okay, they took this type of leave and for these reasons, and does it meet the criteria for the federal tax credits? And then if it does, then you should feel pretty comfortable requesting those tax credits.
Excellent. Thank you. Thank you, Kellen. Next question. I think we have a hard cutoff at 1:10. So this will be our last question that we can take, but I see another one from Deborah Monroe. And Deborah, if you want to email us directly, I think that might be better anyway, because I actually have some clarifying questions about your question. So let's take the one from anonymous attendee. Can we require employees to seek disability pay before using the supplemental paid sick leave? Lindsay, do you mind answering that one?
Sure, absolutely. So employers actually cannot require their employees to use state disability insurance, SDI, to set off or in lieu of providing the employees the COVID-19 supplemental paid sick leave. A covered employee may apply, however, to receive SDI benefits after using the COVID supplemental paid sick leave. But again, the employer cannot require the employee to use SDI first in lieu of the supplemental paid sick leave. The same actually goes for if the employee has PTO or sick leave built up in a bank. The employee is permitted to use the COVID supplemental paid sick leave first, and then before they can be required to use their PTO or other non-supplemental sick leave sick pay.
Fantastic. I think we have a hard cutoff at 1:10. So I want to thank everybody for attending. Thank you for your time. Thank you for taking time out of your busy day to attend a seminar. We know, although we find the law absolutely fascinating and riveting, that we don't always share that interest with everybody else. So thank you for participating. I want to thank our panelists, and I want to thank everybody at the San Francisco Chamber of Commerce, and our slide facilitator, Jessica, our panelists, Kellen Stevens, Lauren Arkadis, and Lindsay Meyer. Thank you, everybody. Have a wonderful day. Be safe out there, and good luck. Take care.
Thanks, everyone.